Great deal. Let's talk a little bit about adverse possession. Now, the key thing here is to understand what the policy is for adverse possession. The policy behind the concept of adverse possession. If you understand this, you should be able to answer any questions that have to do with adverse possession, not only on the test, but also in real life. The key here is this: adverse possession. You want to punish the landowner that sits on her rights. That's what you want to do. We don't want people, owners, landowners, to sit on their rights. Remember, once you acquire possession, and we know what possession is, right? From the wild animal cases and from gifts and finders. Once you acquire possession, what that does is it gives you a bunch of rights, what we call the bundle of rights. The right to sell, the right to partition, the right to give away, the right to do anything as long as what you're doing doesn't violate the law or goes against public policy. Now, since the law gives an owner all those rights, right? The law also says, if you sit on those rights that we so painfully throughout the years have given you, right? We are going to penalize you. That's the key. On the other hand, we want to reward those people that come in and work and take the land and produce on it or make the use of the land productive. However, we just don't want to reward hooligans, right? We want to reward those that rightfully work the land. So there's a series of requirements for somebody that comes in and works the land when the owner sat on her rights and earned it. But it's not just moving in. Otherwise, if we just say, oh, just moving in, it's enough, correct? As a matter of policy, what are we promoting? We're promoting hooligans, people stealing, people sitting there watching, and the moment the owner goes away for vacation, they move in and say, I moved in. So there's certain requirements. And those requirements we're going to talk about are open and notorious, continuous, right? All those things, all the elements that we are going to talk about. That's the policy. Just with that, you ought to be able to answer a question. At least guess intelligently. Suppose that I tell you that owner of Black Acre have not set foot in his land for 80 years. And Bill had moved in there and cultivated the land, took care of the land, built the house, raised cattle. You know, all the neighbors knew that he was there on the land, correct? Immediately, your instinct should tell you that probably in a cause of action between the owner and Bill, who should win? Bill. So now, if four of the choices are two that the owner wins and two of them are the average possessor wins, right? Policy tells you already that it doesn't, based on the policy, that owner should not win. Right? So you're down to looking at the average possessor. Now, the other side says, be careful now, because the other side says, the other side of the policy states that for that average possessor to gain access, he has to do what? Meet the requirements. So what you're going to see in that question is, has this average possessor met the requirement? That's the question. It's not, does the owner win? The question is, does this average possessor who has moved in there, taken care of the land, built a house, raised cattle, right? As opposed to the owner who didn't do anything. The question is not going to be, does the owner win? The question is going to be, has the average possessor met the requirements? If he didn't, of course, then what happens? The owner wins. But if he did, right, he wins. So, having said that, keep that in mind as you look at questions on average possession. And you can't, at a minimum, you have to be able to guess correctly. So if there's 4 questions, you have to get 2. You have to get 2. Now, you think the questions are not enough. Come last year and see how many people are coming to my office complaining because there were 2 questions short of a B. So those are the ones you want to get. So let's talk a little bit about, now that we know the policy, let's talk about the elements. What is average possession about? It's about the running of the statute of limitations. That's what this is. Average possession is about the running of a statute of limitations. Right? The average possessor must be in this land, right, in a certain manner for a certain period of time. That's what average possession is about. So what you're looking is, when do the time start running? When does that statute of limitations begins to run? Because if the statute of limitations doesn't begin to run, then you never, doesn't matter if you're in the land for 100 years, you will not adversely possess. So take that out of your mind, because a lot of you get confused about that. You think it's about how long the person is in the land. It's not about how long the person is in the land. Is, did the statute begin running when that person was in the land? So you can have a person in a piece of property that belongs to somebody else, an average possessor, and she could have been in that piece of land for 200 years. But if she had permission from the owner, it doesn't matter how long she was there, because since she had permission, guess what? The statute did not run. So that's what average possession is about. And I say that because a lot of you come and ask me questions. And it's clear to me that a lot of times the problem with the question is you know the rule of law, but you don't understand the principle behind it, and you get confused. The moment you see a question that says, oh, average possession was on the land for 50 years, you jump. Oh, 50 years. Right? And there's one little thing missing. One little thing missing. She had permission. By the way, all the elements must be met, not one. So even if the person is there continuously for the statutory period, openly and notoriously, if she had consent, just that one element, no average possession. So that's the background. So let's talk about the elements. First, we know that possession must be hostile. Now here's the problem. Laypersons think of hostility, and I've said this in my class 100 times. You think of hostility as spite, hate, dislike, correct? Erase that. In terms of property, in terms of the concept of average possession, hostility has nothing to do with feelings. Hostile simply means you are there without the permission of the owner, and you're doing something that is against the interest of the owner. That's what hostile means. You can be the nicest person in the world, the most loving person in the world. You can be the person that doesn't have any ill feelings towards anybody in the world and still be possessing land in a hostile manner. Now, that should have been a confusion for you in the beginning, when you started law school, right? But by now, you have to be understanding that sometimes in legal terms, things don't mean what they seem to mean. So now we know what hostile is. So what's the big hoo-ha confusion about in terms of hostile? I tell you what it is. For some reason, textbooks want you to learn how to think like a lawyer. And a lot of times, the textbook gives you cases, right, that are right, but are not what is considered the majority rule. And they give you that to point to you to the exception. So for a little while there, we talked about intent. Did the person intend it? The state of mind of the person. Some of the cases. particularly in borderline cases, right? Where it's in borderline cases is probably the place where courts are most likely to look at the intent of the parties. Not that they will, but they're most likely to look at the intent of the party in borderline cases. But in general, right, the majority of courts, the majority of jurisdictions do not look at the state of mind of the average possessor. It doesn't matter if you knew when you moved in there that you were moving to somebody else's property. It doesn't matter if you were totally innocent, right? It doesn't matter what you were thinking. If you moved in there, if you met the elements, and if you were doing something against the interest of the owner, even if you didn't know about it, even if you knew about it, it still is hostile. Special cases where you don't find hostility, hostile element. I hate to use the word hostility. The hostile element is not met. Co-tenants cases. Two people own land as joint tenants. Now here we go. When we discussed average possession the first time, you didn't know anything about joint tenancies or tenancies by the entirety or tenancy in common. So we're going to speak like this, but now we can, right? Say two people are joint tenants or tenants in common of a lot. One of them happens to live in England. The other one lives in the land for 100 years, right? That person living in the land is not hostile. Doesn't meet the element of hostility. Why? Because they're not there against the interest of the co-tenant. They have a right to be there by virtue of having the right to share the possession of the property. There's one exception to that. And the exception to that is when one of the parties ousts the other one. Now, what is an ouster? Well, I think in general it has to be more than simply verbal. There has to be some action that is significant. Usually it is an order from a court, right? And when a person brings an action, when one of the co-tenants brings an action against the other one because they're being ousted, the remedy is not to kick the other one out. The remedy is simply to force them to share in the land. That's the remedy. That's ousting. The other example is that we know of is landlord-tenant. Right? When you have a tenant that signed a lease, that tenant is there with what? The consent, permission of the landlord. So that tenant will never acquire average possession on the property. Doesn't matter if you live there for 100 years. Is it possible? Yes. When landlord evicts you, goes to court, gets a judicial order, kick you out, leave, right? Now we have some drastic measure. That's almost like an ouster. You stay there. Landlord doesn't do anything. Landlord forgets that you're there, and you remain there for 30. Now we have changed the relationship between landlord-tenant to one of average possession. Those are examples of situations. Some typical examples where the element of hostile may come into play. And pay attention to that. Pay attention to that because it's so easy in the, I want to use the word, in the heat of the test, right? That you see a fact pattern that talks about one of the parties, right, tells the other one, you're in England, never come back again, right? And then the question is about average possession. That's not enough. Just because you called them on the phone and said, don't ever come back again. That's not an ouster. But it's easy to jump and say, oh, average possession, because what are we going to do? We're going to trick you, and we're going to make that person live there for 100 years. Okay? We're going to give you everything that looks so good. The co-tenant lived there for 100 years. Co-tenant built a fence. Co-tenant bought a rifle and said, if he ever comes around, I'm going to shoot him. Co-tenant called him on the phone and said, don't ever come back. That's all. but the co-tenant never actually came over. Well, is there adverse possession? Not yet. There's no ouster yet. Ouster means you didn't permit the other party from coming in. All right. The other, let's talk about one that is more common, open and notorious. What is that? Well, it's simple. The possessor must, in some way, through his or her actions, notify the owner that I'm trying to take away your property. That's the key. Look and see if what the person is doing puts the owner on notice. Actual inquiry, whatever. Owner knows or should have known. Are the actions of that adverse possessor of such a nature that it puts the owner on notice that I'm trying to take your property away? Suppose owner has a piece of land in California, 20,000 acres. And an adverse possessor, a person that moves in, adverse possessor, and he puts a stick in the middle of the land. Little stick with a flag. This is my property. Right? Nothing else. In your opinion, is that sufficient? In my opinion, no. Because I'm the owner, I see that flag there, I could say, well, somebody was here visiting, left a flag. You know, it doesn't tell me that somebody is trying to take my property. All it tells me is what? Somebody left a flag. Right? But if I come into the same piece of land and I find a house built in the middle of it, or if I find a fence with dogs, with killing dogs, or if I find a camping site that seems to be pretty permanent because it has water running in, a sewer system. Now, what does that tell me? This person wasn't here just for the fun of it. This person is serious. So that's what you're looking at. That's the key. You're trying to see, are the actions of the adverse possessor of such a nature that it notifies, it puts the seller on notice. Usually for houses, when somebody builds, let me start again. Usually, in terms of possession of land, the test is, has the owner is the adverse possessor using the land in the same way that the owner would? Right? That's when it comes down to land. That's not the same thing for houses. But in general, the legal standard is for land, is the adverse possessor using the land in the same fashion that the owner would. These are all your examples in Barbary and commercial outlines about grazing cattle that moves in and out. Yesterday somebody asked me a question. If one cow moves in there for one day to eat, right, and then comes back, that's not going to be enough, right? Because usually that land, if it's grazing, for feeding cattle, it's not going to have one cow. So you look at that. Otherwise, what you look at is what's the use? Is the use of it sufficient to put the owner on notice? For example, if there's a house and somebody lives in it, right? Well, that may be, if that person has a vegetable garden, if that person puts a fence, right? It's not that they're using the house, it's that they're using it in a way that tells the owner of the property, I'm taking over your house. You can see why we have a slightly different view of land as opposed to buildings, like houses. It's easier to know when somebody's trying to take over your land, your house, than it is when somebody's trying to take over your land. So the court is going to be a little different in the way they view this, right? I mean, a house is easy. You walk in, your furniture is gone, new furniture is up, new curtains in the bathrooms, dishes, all that stuff, right? What's that tell you? It's easy. Whoa, somebody's setting it in. But if you come in and you see one cow in there, that doesn't tell you a lot. So that's why there's a slight difference in the way courts see the average possessor in terms of land as to houses. But it all comes down to this. And I say this because, in real life, you have time to think, to analyze, to argue. In test, you got 2 minutes. 2 minutes. So what it comes down to is this. Understand that the key idea is not how it's used, whether it's land or a house. The key idea is the average possessor using the property in a way that an owner, a reasonable person, that saw the actions or should have seen the actions would have guessed or thought or felt that somebody is taking away my property. That's the key thing. Is the average possessor using the land in a way that puts the owner on notice. So if you get all confused because it's a piece of land or a house or a trailer or a river or whatever it is, right? And you're confused and you don't remember exactly, try to use that idea. Look and see. Is this average possessor using the land? We have a case in the book, which is weird. It's a New York case, where the person, the average possessor actually farmed the whole lot, remember? And sold the vegetables, and everybody in town knew that the family was selling the vegetables from that lot, and yet the court said it wasn't open and notorious. That's strange. I believe that the difference in that case, it was because it was a statute, and the statute mentioned fences and a lot of other things. So they were reading the statute, and that's what made it difficult. But nevertheless, don't worry about that case. That case is there to make a point to you that there are statutes, and you have to read the statutes. And in New York, the statute kind of departed a little bit from what we call the majority rule. And they're trying to give you the exception. Again, in general, putting the owner on notice. Is the owner on notice when the owner suffers a disability? Now, we had a problem with this because when we did disabilities, we kind of did it independent of everything else, right? And we have to now, in reviewing, hook it up, tie it up to the notion of notice. All this disability stuff we did is nothing but discussing the concept of notice, right? Is it open and notorious, right? Well, if the owner is insane, or if the owner is a minor, she can't be on notice. How can you have been given notice, or how could you have known that somebody was trying to take the property from you if you don't even know where you are? I mean, you're schizophrenic. For all that we know, you think you're in the moon. Now, how do you know, if you don't even know where you are, how can you know that somebody's trying to take your property away from you? Right? Now, in general, the disabilities that are mentioned all the time are insanity and minority. Right? Those are the general ideas. However, look at the statute. In some jurisdictions, being in prison is a disability. In some jurisdictions, being a drug addict is a disability. In some jurisdictions, being an alcoholic may be a disability. It all depends what the jurisdiction has, what the legislature in that state has decided they're going to consider a disability as far as notice. As far as notice. They were clear about that. Now here's the point. Generally, under the traditional common law, where there's no special statute, the person, the owner, remains without notice until that disability is removed. Period. That's the traditional common law. So if you are dealing with a problem that doesn't deal with a special statute, and most of the time in most jurisdictions now there is a statute, so in all likelihood if you get a question in the test or in the bar exam, they're going to give you a statute, in most likelihood. But if they don't, you're dealing with the common law. In the traditional common law, the owner is not the owner of the land who is disabled, meaning insane or minor, right? Is not on notice until that disability is removed. Usually, when is a disability removed? Well, if it's minority, when you turn adult. And again, you have to read the statute, because in some places, right, the age of majority is 18. In other places, it's 21. Right? So it doesn't, oh, but 20 years old. In Wisconsin, that's an adult. Yeah, but in Texas, it might not be. So how do you decide if the person has reached the age of majority? You have to look at the statute. That's it. That's all there is to it. You look at the statute. And if the statute says 21 years, that's what it is. If it's not there, for some reason, and I don't think that we do that in the property test, because we're very careful when we write it, if for some reason it's not there, two things may happen. One, it's irrelevant, and don't look for it. Or two, we made a mistake, and in that case, the question is probably going to be thrown out, because we will give you. So what do? You answer it assuming the age of majority is 21. Just answer it like that. Assume it's 21, and then we'll deal with it. But in general, you will notice that half of the time, when it's not there, and people want to come up, which we cannot do in the final exam, but Professor doesn't say anything here about the age of majority. Probably what that means is it's not relevant. It's not relevant. Some jurisdictions, if not most, have decided to deal with this problem of this disability by what we in my class know as 1020, 1021, 1015, whatever you want to call it. It's a statute that says the statute begins to run. In other words, the owner would have notice. As far as notice is concerned, the statute would begin to run as far as notice is to the owner is concerned. 20 years from when the action accrued, or the owner may bring an action within 10 years after the disability is removed. May. So there's a choice. You either go with the regular 20 years, which is, by the way, I said 21, it's 20 years. No, for the statute, the statutory period in most jurisdictions is 20 years. Right? Not all. So it's either the owner can bring an ejectment action within those 20 years, or even after those 20 years are there, right? 10 years after the disability is removed. So here's what I have pounded on you all, and maybe we'll have time to do some problems today. Here's what it says. You take the moment the average possessor moved in. If you have this statute, and you count 20 years from there, if it's 20 years. If it's 1510, then 15 years. Regardless of the disability. Because what it says is 20 years from the accrual of the action, right? Or 10 years after the disability is removed. So you start counting from when the action accrued. 20 years. Then you do a second test. And you do 10 years after the disability is removed. And then you do what? You pick the largest. what did I emphasize is there's a tendency in the beginning for first-year students to not understand this, and they try to add the 20 years from when the disability is removed. In this type of statute, you count the 20 years from when the action accrued, regardless of disability. And then you do another count 10 years after the disability is removed, and whichever one is larger, that's the one that goes. Why that rule? Because you never want to undermine the 20 years. You never want, if the state said 20 years after the action accrued, and when you do the 10 years after the disability is removed, comes out to less than 20 years, it's attacking itself. So it would never be less than that limitation that was prescribed in the statute. That's what disability is. And we know that as modification of the common law rules. So to recap, what do? First, you decide if there's a statute. The statute might simply say, action begins to run 20 years after, 20 years, the action begins to run when the possession is actual, hostile, open, and notorious, and continuous. That's what it says. In that case, you're going to do 20 years after the disability is removed, right? But if the statute says 20 years after the statute is, the disability is removed, or the owner may bring the action, or may bring it 10 years after the disability is removed, now you have to do the two tests. Now you have to do the balancing. So far, so good? Yeah. All right. So now we know that it has to be actual, physically. You have to move in there. You have to. You cannot acquire average possession by mail. You hear a lot about, in the majority of jurisdictions, some jurisdictions paying the taxes is enough. That's a very small number. You cannot acquire average possession of your neighbor's house by paying the taxes every year. I mean, it has to be actual in the majority of jurisdictions. We know it has to be hostile, meaning without permission of the owner. In the majority of jurisdictions, intent is irrelevant. Right? Intent is irrelevant. We know it has to be open and notorious. And that means he has to put the owner on notice. We know that an owner is not on notice if the owner suffers a disability. Right? And the disability might be insanity, might be a minor. Now you know from contracts how we see minors. You know, for some reason, the legislature have decided that if you're 20 years old, you can go and fight a war, you can get married, you can work, you can do anything you want, but as far as the law is concerned, you're incapable of knowing that somebody's trying to take property away from you, or you're incapable of entering into a valid contract. It's kind of silly, isn't it? But that's the way the law functions. One of these days that's going to disappear, I predict, because things have changed so much. The next thing is, not only does he have to be open and notorious, hostile, right? Actual, it must be continuous throughout the period. Now here is something we have to separate continuity from the rest of the whole pack of requirements. The requirements of open and notorious, actual and hostile, what do? They trigger the statute. They are questions, these are issues that go to the issue of whether or not the statute begins to run. It's important that you understand that, because that's the essence of the question. Is the question about the statute running, right? Or is it about, while it was running, did I meet the requirement of being there for the amount of years? Continuity is an issue that comes up when the statute already started running. You don't start worrying about continuity until the statute begins to run. Once it begins to run, you must be in that property for the statutory period. But if it doesn't begin to run, you don't count the years. So that's a little difference between the two of them. One thing we learned from the Lutz case is seasonal. Even though we require the person to be physically there in the majority of jurisdictions, right? It doesn't mean in some instances that you have to actually be physically there for the period. In some instances, right? You only need to be there for a certain amount of time. If the property's use is seasonal, is a summer home, right? That's the use of the property. You don't have to be there the whole year. All you have to be there is continuously during the summertime. That's what the seasonal cases are, right? But the biggest issue here is about what you heard in class known as tacking. That's the problem, tacking. And what is tacking? The average possessor is entitled to the period of possession of a prior possessor if he's in privity with the prior possessor. An average possessor is entitled to count the period of the prior possessor, right? If the possessor is in privity with the prior possessor. Whoa, the word privity sounds a lot different now, doesn't it? Than when we did average possession. Remember? Now we've had easements and covenants. Privity, horizontal privity, vertical privity, right? We have a better picture now of privity. And what's the essence of privity? A legal relationship. A legal transaction. Whether it's a gift, whether it is a sale, as long as there is a legal transaction. There's a legal transaction. Mom is in the land. She calls me up and she says, you know what, son? I cannot live in this house anymore. Why don't you move in so I go to a nursing home? Right? Privity. Son came in at the request of mom. There was a transfer of the property. Legal transfer? Of course not. You know, we know now that legal transfer is done with deeds and pieces of paper and, and there's intent and all those things. But nevertheless, there is a transfer. There's a transfer. Here is a couple of rules we need to remember. If an average possessor is forced out, right, the statute stops. However, if that average possessor regains the land, the statute begins to run again. So I've been by anybody but the owner. Remember, if the owner kicks you out, that's over with. You never regain that time. Right? Our ownership stops. When the owner moves in and kicks you out, that completely stops the statute. I'm not talking about an owner. I'm talking about a successor. A person before you. I'm not a successor, a predecessor. Okay? Somebody before you, not the owner. And I'm clarifying that because that came up with my class, with you guys, during the test, and somebody asked that very good question. The owner moved in and kicked the person out, and then the person moved in again 3 years later. Does he start running again? No. He starts running again, but the key here is you cannot start using the time before. It's only when it's a predecessor, somebody before, a previous person, a previous average possessor. English gets weird sometimes. I can do this in Spanish better. I'll lose you. All right. So if they do that, right, you can regain it. If you leave, right, and you leave the property with somebody else, and then you come back, you can regain it. That's that. In terms of succession, let's clarify this now, because I said at the time that we discussed this in class, we need to put it to the side because we had not done estates of future interest, right? But now we can put it together. That's what reviews are for. Now is the end. So we can say this now, and hopefully you understand. The statute does not begin to run against holders of future interest until that land, until that property becomes, or until that grant is, until it becomes possessory. Until it becomes possessory. O to A for life. Remainder to B. Right? A moves into the property, doesn't take care of it. A lives for 50 years. She moves away from the land, right? In the meantime, an average possessor moves in, meets the statutory period, right? Open and notorious, hostile, continuously, all those things, correct? That average possessor has now acquired rights as to the life tenant. But the statute doesn't run against the holder of the future interest until that life estate is over. Is over. Here's a nifty way for us to see if you're thinking. It's a nifty way to see if you're thinking. We give you O to A for life, O to A and his heirs, then to B. Let's look at that example again. O to A and his heirs, then to B. Right? A dies. In the meantime, somebody was living in the property, meeting all the elements for 50 years. B comes in and says, aha! I can kick you out. I'm the heir. Right? I'm the heir. Or the land comes to me in a will because the statute doesn't run against the holders of future interest. Your answer is what? No. Why? Because in this case, B is not a holder of a future interest. B has what? Nothing. B has nothing. You'll be shocked how many classmates of yours would jump at that and forget that the rule is about the holders of future interest. And the holder of future interest in the grantor are reversions, possibility of reverter, right of reentry, inter partes, executory interest, or remainders. If it's not one of those things, the statute runs. The statute runs. Now, you have to be proud of yourself. Because I just said something in 2 minutes there, that if I would have said that to you when we're doing average possession, you would have gone, huh? But now you know, right? Now you know. Hint is not about the time the person is gone. It's about notice to the owner. If I leave for a funeral and I'm gone for 1 week, correct? I wasn't there for a week. But if I left behind still the signs that I'm in that property, right? So that the owner would have known, if the owner came around, that I was living there, right? Then, even though for those 5 days I was gone, I'm still there continuously. But if I leave, and I pack my bags, and I clean the house, and I approve the plans, and I take down the mailbox, and I take my furniture, and I leave for 1 day, and then decide to come back, it stopped. It stopped, because if during that day the owner will come, what would the owner think? Somebody was here, but they left. You understand? So that's what you got to look at. Don't be fooled by a person went to a funeral, and then once they were there, they discovered that there were problems they had to take care of. They had to take care of the wills, so it took a little longer, right? So when they came back, does the statute start running again? No. If that person left. Hey, the neighbor, cut the grass for me. Pick up my newspapers, right? If the grass was being cut, the newspaper being picked, that's enough. However, if you left intending to come back, but you never left any signs behind, the grass kept going wild, you didn't have somebody mowing the lawn, then it doesn't matter what you wanted. The fact is that as to the relationship with the true owner, when the true owner comes and sees the grass that's not mowed, right? What is he going to say? Nobody's here. So those are the little things that are tested, that you must be paying attention to. Because we like to do that. We like the person to be gone for 6 months, right? But in the meantime, they let the neighbor cutting the grass, picking up the newspaper, watering the lawn. And somehow the student doesn't see the cutting the lawn and mowing the grass. I mean, they only see the person left for 6 months. That's what they see. They don't read the rest of the question. And we're trying to see if you understand what continuous means. What continuous means. What interrupts, and we're almost done, folks, believe it or not, then we'll do some problems. What interrupts continuity? Well, the owner moves in. The owner moves in. That interrupts because one of the requirements is that it must be exclusive of the owner. Right? Exclusive of the owner. If another average possessor lives there, that doesn't take away, it doesn't stop the statute. It's exclusive of the owner. An ouster. Physically, the owner comes in and moves your furniture out. Physically, the owner comes in and padlocks the door. That's an ouster. Or a judicial action. It's called an action on ejectment. It's called an action for ejectment. What kind of title? Now here is where we add some new stuff. When you get title by average possession, you're the average possessor. What kind of title do you get? It's a new title, which means it's not even subject to defects that are found on the record. Wow! Have I said that to you again 4 months ago, 5 months ago? Would you have understood that? Defects found on the record? But now we know. If there's a gap in the title, right? That still, since you're an average possessor, is not subject. It's not subject to liens. It's not subject to any encumbrances. It's not subject to any of the things that make the title unmarketable. It's a new title. This new title is valid, is alienable without a judicial decree or recording. Is valid without judicial decree or recording. Now, the fact is this. Here is the trick. Now, you want to sell it, right? And you don't have the title, right? The new person that's going to buy it from you says, hold on a moment. There's a problem here. I don't see the title, right? In that case, for you to make sure that it's perfectly marketable, right? Marketable, what do you have to do? Go to court and quiet title in you. One last thing that was a point of confusion. This business of constructive possession on the color title and claim of right. Because it seemed that, incredibly enough to me, that was the most confusing thing for everybody this year. Usually the confusion is about disabilities. This year, it was about color title. And let's do it like this and over with. No, nothing more. Listen to what I'm saying carefully. If you get title by a defective deed, right? If you get title by a defective deed, or a deed that has mistakes on it as to the land, the property, correct? That you got it by a deed. So you got it by title. That title, that's what color of title means. You acquired it by virtue of having received a title. Since you received a title, correct, you get possession to the whole. Listen to the words, color of title, right? Color of title. What it means is the title gave you, by virtue of the title gave you ownership even though it was defective. That's what color of title is. If there's no title, if you acquire possession by a mean other than a title, correct? What that says is you came in there on the claim of right. And at that point, you only get possession to that which you own. So what do you look for to know whether it's color of title or claim of right? Is there a deed? Is there an instrument? Is there a title? Right? Because title gives you property. Now, once you get that title, if that title is defective, it doesn't affect you. You still get the property on the color of title, and you get possession through the home. All right. What I want to do now is, I want you all to statute of limitations not running against the holder of a future interest. Let's go back to that point. That only occurs if the grant was before the average possession. All right? If the grant is after the average possessor moved in, it starts running even against the holder of a future interest. Otherwise, it doesn't make sense. The owner could very well do what? Come up with a grant. I'm in trouble, right? I got 1 day left. I can't go to court to get an action. So what I'm going to do is I'm going to give it to my wife, life estate remainder to be. Oh, it stops running. No, it doesn't work like that. So I forgot to mention that this morning. Everybody, don't clap because next door neighbor.